But I'm very excited about this panel. We've got some great presentations. So without further ado, I think, Simmi, do you want to kick us off?
Thank you.
I'm going to let my distinguished speakers introduce themselves as they do their presentations. So please feel free to take some time and do that. And I see we have Nico. Nico, you're going fourth. So great to see you. All right, Simmi, please.
Hi. Hello, everybody. My name is Simmi Sandhu, and I'm the chair of the Civil Resolution Tribunal of BC. You've heard a little bit about it in the last panel. And I'm here to talk about the CRT, our experience, and some lessons that we've learned. Okay, so I've got lots of slides. I'm not going to go through them in great detail. I'm going to go through them fairly quickly. Let's get this set up here. Can we get it set up?
Yes. There should be a remote controller for you.
The controller?
That's the remote controller if you want to.
Sure. Do you want to start from the beginning?
Yes, that's the beginning. That's
Yeah.
the first one.
Okay, there we go. Okay,
Do you wanna-
thanks.
All right, that's right.
All right. I became involved with ODR platform while at the Property Assessment Appeal Board, and you heard a little bit about that in the last presentation as well, last panel. And that tribunal started offering ODR as an option back in 2012. And it was a platform first developed by Montreal, and then in recent years, a platform developed by the Justice Education Society. And that experience led the government of British Columbia to think about how ODR could be leveraged to respond to access to justice challenges being faced in Canada. And that ultimately led to the creation of the Civil Resolution Tribunal. So what is the Civil Resolution Tribunal, or the CRT? It's an administrative tribunal. It is part of the civil justice system of British Columbia. And when it opened in 2016, it was the first fully online tribunal in Canada and one of the first in the world. And it was created in response to increasing dispute volumes and delays in the court system and increasing costs of the public in accessing the court system. In 2020, the Canadian Forum on Civil Justice found that over a 3-year period, almost half of Canadian adults will experience at least one everyday legal problem, but only 19% would seek formal legal advice. According to this research, at around 6,000 Canadian per dispute, Canada spends nearly $8 billion on everyday legal problems. So in response to this, the government of British Columbia created the Civil Resolution Tribunal as an initiative to improve access to justice beyond the courts by first diverting certain dispute types from the court system to the CRT in order to reduce the court's workload, and second, beyond that, the government viewed this as an opportunity to use ODR to transform how we deliver justice services, but not by simply replicating existing court processes online. ODR is not a panacea for the access to justice crisis. By simply providing the same process online does not necessarily mean accessible and equitable justice. Rather, it's an opportunity to re-examine our processes with the intention of transformation by first speaking to the people that use the system. Ask them what are their needs and preferences, and then design a process that meets those needs using technology as a tool. Again, stated by the Canadian Forum on Civil Justice, for decades, we've tried to understand access to justice by looking at the providers, meaning the lawyers, the courts, and academics in the system. What we need to do is start looking at the users, the public, by adopting a user-centric approach. And a user-centric approach requires us to ask the public what they need from the civil justice system, which can be done through various methods, including focus groups and surveys. In 2015, the government completed surveys. Participants overwhelmingly indicated they were comfortable going online. 6 in 10 preferred to go online to seek out information about small claims and condo disputes. 81% said that they would use an online civil justice service that was user-friendly and available 24/7. They preferred asynchronous participation online compared to in-person scheduled meeting or hearing. All of this helped the CRT to identify its requirements to produce its process. So once the requirements were identified, the design prototype was created, and the better version was tested through focus groups that consisted of users identified by stakeholders. In addition, we conducted user observations. All of this feedback was critical in designing and refining our process. And after launch and production, we continue to get feedback through regular user surveys and our commitment to continuous improvement. So in 2016, CRT opened its virtual doors with condominium disputes, and over time has added different jurisdictions such as small claims, certain motor vehicle disputes, all of which previously had gone to the court system. In 2024, the CRT will receive a new jurisdiction over the non-consensual distribution of intimate images online. And this is an interesting jurisdiction. I'm going to spend a little bit of time on this. And it's going to be unlike anything seen in Canada, by the way. The legislation authorizes the CRT to issue an order that an individual, named or unnamed, or an internet intermediary stop distributing the non-consensual distribution of intimate images, and to take down that image from their internet platforms. It also gives the CRT authority to issue damage awards and penalties. We're developing the online portal now and the processes that will allow the applications to be filed online and for the CRT to issue the takedown order within days of the application being made. It is concurrent jurisdiction with the courts, but unlike the courts, all of our processes will be online, including the upload of the image, upload of evidence, and issuance of the orders. In addition, minors and youth will be authorized to come to the CRT to make these applications on their own as well. So we're developing our Solution Explorer for this jurisdiction. We're developing the online technology to allow safe and secure applications for these orders, and that includes currently doing user testing for that technology and consulting with stakeholders. All of this is part of our user-centric approach in designing the process for any new jurisdiction. And part of that approach is the website is designed first and foremost to work well on smartphones without downloading any apps. We use a responsive design to move seamlessly between different devices, and that works well on all of them. So you can handle your entire claim and application from the Solution Explorer to diagnose and get legal information, to filling out your application, to responding to settlement discussions, or uploading your evidence, and then reading your decision all from your couch or wherever you have to be at any time of the day. This is a basic snapshot of the CRT process, and I think, again, some of this was touched on in the last panel. There's 5 stages in the process, each supported differently by technology. And it begins with the self-help phase. Using the website and our Solution Explorers, we give people free, upfront legal information. And I'll talk about that in a little bit more detail. After applying online to the CRT, the parties then have a chance to negotiate through a voluntary online chat room or negotiation platform. And just as an aside, we've learned that to the extent that you can design legal technology that looks like what people are already comfortable with, they will have less problems. So a lot of our ODR technology looks like existing social media pages, e-commerce pages, and chat rooms. If there's no resolution after negotiation, the parties then go to mandatory facilitation, where CRT case managers get involved and try to mediate the dispute. And if there's no resolution then, it then goes to the adjudication stage, where parties upload their written information, which is then accessed by a tribunal member through an online portal, and they then issue the decision electronically, all of this online. Now, with the intimate image protection jurisdiction, the process will look a little different. There will likely be no negotiation phase, and the facilitation phase will look different as well, because that speaks to the sensitivities and vulnerabilities of those particular applicants. So the entire process is conducted online. However, as a public access to justice project, we must offer different options to people. So there are a small number of people who want to use letters to communicate with us, and we allow that. We offer paper forms, telephone service, as well as the in-person service at government offices throughout the province. So to be truly accessible, we have learned that we need to offer different ways for the public to engage with the CRT to ensure we are servicing all British Columbians. Just want to go through the stages in a little bit more detail. This is the Solution Explorer stage, and it speaks to a fundamental access to justice gap. The gap that people need for legal information and the accessibility and affordability of obtaining that information, which is often in the purview of lawyers and legal professionals. We start with the proposition that our online Solution Explorer can provide help and support to resolve a user's dispute without a lawyer and give them the resources to do that. So the Solution Explorer provides legal information through guided pathways, where the user is asked a series of questions and provided targeted legal information depending on their answer. At the end, there are options for the users, including letter templates and resources. It's free, it's anonymous, it's available 24/7. And like everything else at the CRT, was designed with user feedback and user testing. Here's a screenshot of a Solution Explorer for small claims. The user clicks on the general topic area and they're asked a series of questions. Here's one regarding loans. The user picks one or more of the situations that apply, and the system leads them through each issue in turn. The idea is you ask questions and then give people plain language legal information. And on the left-hand side, you'll see additional resources are provided throughout to give them more specific legal information. And here's the resource that they would get at the end. This is an example if you cannot pay a debt or loan. So everything written in the Solution Explorer on the website or decisions are written in plain language at a grade 6 to 8 reading level, which is the average reading level in Canada. You also see at the top corner a something broken button. And this allows users to provide feedback on the Solution Explorer. And this feedback comes to the CRT immediately. And we review it and use it in our quarterly refresh of the Solution Explorer. And then once they're provided the legal information, we ask them what they would like to do next, whether it's negotiating with the lender, speaking to someone, or making the application to the CRT. If they want to negotiate with the lender, here's a letter template we give them. They can use this template to edit, save, and print and send it to the other party to try to negotiate a settlement. At the end is a summary report, which gives them the links to all of the resources in plain language, and the users can scroll down and then make an application to the CRT immediately. In 2016, we had approximately 230,000 explorations on the Solution Explorer. Although we do not track the outcomes, we have not received anything near 230,000 applications to the CRT. So we have to assume that some of those explorations resulted in users resolving their legal problem without making an application to the CRT. Well, they can still apply to the CRT, and it's a basic online form, and it's basic because we know that court forms are notoriously not user-friendly, and we've again designed the form using user feedback and user testing. We also ask applicants for certain information to better serve them, including their preferred pronouns, and to ask them to self-identify. This allows us to be respectful in addressing them throughout the process, which is extremely important when you're online. We do not track this information, however. We ask them if they need additional supports, accommodations. For example, if they have literacy or language issues. If so, we have staff, including navigators, they're called navigators, who help the party to navigate them through the system. After the application, they go through negotiation, as I said. They're encouraged to log in to their CRT account to access the portal, and here's a screenshot of that. They can discuss their dispute with the other parties in a confidential forum to see if they can resolve it. The CRT does not get involved in those discussions at this stage, and we do get some resolutions here, but not many. If there's no resolution, it then goes to facilitation. Sorry, I don't know what happened there. Sorry? I'm missing slides. Okay. That's fine. Are you sure it's not all there?
Didn't look like missing slides, it looked like it crashed out.
Yeah.
Can we just restart it from where we ended? Yeah. A little bit higher up, yep.
There we go.
Roughly there, facilitation.
Yeah. All right, facilitation. This requires the intervention of case managers who try to mediate the dispute with the parties. And this process is flexible. It can be synchronous or asynchronous depending on the parties' needs and preferences. To communicate, parties can use the telephone. We use Teams to video conference, email, or messaging platforms. And the most common tools are phone or email. And this is a mandatory stage in our process. You do not have to reach an agreement, but you do have to participate in the process. And if there's no resolution, only then will it go to adjudication. And we have about 25% of disputes go to adjudication. And these are for decisions that CRT decisions that are enforceable and binding in court. The adjudication process is also largely online. Parties use their CRT account to upload their evidence and written argument, and we have ability to accommodate here as well. So for those that have literacy or language issues and can't communicate in writing, we offer oral hearings. Not many. There's maybe been about 3 or 4 since 2016. If they can't use technology, they can use mail or courier services to submit their written submissions. Again, this is very rare. Over 95% of users use the online portal. And this is what that looks like. Parties can upload their evidence and submissions at any time, 24/7. They can participate wherever they are, at home, from work, on vacation, and from any device they like. And then the tribunal member accesses that information through their own portal to view the material and then issue the decision. And that decision is in writing and issued electronically as well. So the CRT's mandate is for accessible, timely, flexible, affordable, and efficient dispute resolution using technology as a tool. The services can be accessed online 24/7, although we do offer phone services and other alternate processes to be truly accessible. If you can't afford the fees, there are fee waivers for those that are on disability or income assistance, free legal information available 24/7, free language interpretation over 200 languages, and flexible facilitation process, and a commitment to continuous user feedback. And as part of that commitment to continuous user feedback, we survey our users constantly. These surveys help us to evaluate and improve our processes, but it also allows us to identify any pain points in the process and to address them in real time. We publish the results monthly, regardless of the number of responses we get, through our website and social media. And we have learned that it's important to incorporate continuous, regular user feedback as part of any process design. I just want to pause here to speak to a point made in the last panel on accessibility of ODR. We do not track our parties and some of the characteristics, but in this survey we do, and the survey responses show some interesting statistics. Over 95%, 97% of our survey participants have English as a first language. 70% have a university or college degree. A majority of them are from urban areas of British Columbia. So we can't come to concrete conclusions about these statistics, but they paint a picture. And that's a picture that we need to do better in reaching out to marginalized communities and marginalized groups. So continuous improvement, we ask for user feedback regularly, we review it. We then incorporate what we can in improvements in our process, which is then subject to more user feedback. So what are some lessons that we've learned in our experience? We've learned that the use of online tools is a starting point, but not the complete answer to access to justice. ODR's value lies in re-examining our processes with the intention of transformation through the user feedback within the parameters of the legal principles we operate in. We've learned to regularly ask for feedback and be flexible and ready to institute changes based on that feedback. We have learned that in a user-centric approach, user test everything at every stage. Observational testing, surveys, focus groups, interviews, consultations. And we've learned that in doing that, we must include users from marginalized groups. So don't forget that. We've learned that we need to make legal tech feel familiar for the public, implement in stages, make decisions on user data, and ensure flexibility is incorporated into any system so it can be updated and responsive to changes. What doesn't work? Getting too attached to one way of doing things. Don't be wedded to past practices or existing practices. ODR is not a panacea to access to justice challenges, not alone. Don't assume IT professionals or legal professionals are good at guessing at what the public wants or needs. Be transformative Do not let the fear of failure be a barrier. And don't focus on perfection for every single possible scenario or outlier situation. And importantly, don't automatically embed existing practice in technology or ODR. Resist the urge to simply digitize the status quo. More than anything, the use of ODR is an opportunity to reassess the delivery of justice services, to identify obsolete ideas and innovate. What that looks like will be different in national jurisdictions or provincial jurisdictions, in different legal systems and justice sectors. However, by using legal technology with process transformation, we can truly address the access to justice challenges that we all face. So thank you. Happy to answer any questions now or later.
Wow, that was one intimidating looking cow. I would not want to pave that cow path. That cow was like, don't pave my path. I've said this to you many times, and we've had presentations on the CRT for years, but kudos to you and your team. Every time I see a presentation about the CRT, I think, why is it that every court does not work this way? And also kudos to you for embodying, I think, a lot of the values and ethical guidelines that we have in ODR practice. You've done such a great job with transparency and with supporting. Very excited about your new caseload. So maybe when we get to the Q&A, we can talk about that, because it does sound quite a bit different than for the facilitation caseloads. Does anybody have any clarifying questions for Simmi before we go? Because we are going to have a Q&A period. Yeah? Okay, we can do it later too. Don't forget, write them down. Okay, Michael, please, you're next.
I'm sorry,
Oh, yes. Do we have something online?
Yes, I added a question in the chat.
Mirez.
And hi.
Hi. You're coming through the speakers. This is amazing. Do you want to just restate your question verbally?
Yes, sure. I'm not able, apparently, I'm unable to put the camera on. So my question is to know how many, this is absolutely excellent. I'm also amazed at the evolution, and I was going to say the same earlier to Darren. So my question is to know if you have statistics about the number of cases filed and the number of cases settled amicably or otherwise. That's always interesting to see, because the profile, the profiles that you have provided us in terms of percentage is absolutely excellent, and that shows the widespread of users. But I would be curious also to know if you have statistics about cases.
Sorry, just to clarify, and thank you for the question. I think what you're asking is the number of cases that are filed with the CRT and the settlement rates.
Yes.
Is that correct? Okay. So we,
That's right.
in terms of the number of cases filed, in 2022 we had 5,600 cases or disputes filed with the CRT. I would say about 3/4 of those were small claims. The small claims jurisdiction, we're getting a lot of disputes in the small claims jurisdiction, small claims under 5,000. In terms of the settlement rates, we don't keep track of the settlement rates, but we do know about 25% of disputes go to adjudication. Now, the 75% that don't, some of those, the majority of them settle, but there's also some disputes where we don't have jurisdiction or they withdraw. So I don't think we have the settlement rate out of that 75%, but 25% do go to adjudication.
Right, and do you publish any of these numbers, or this is out of the numbers that you usually publish?
Absolutely. They're published on our annual reports. Our most recent annual report for 2022-2023 has just been uploaded onto our website, and you'll see some more statistics in that report.
Thank you very much. When I heard you, and when I heard earlier also Valent and Darren speaking, I thought, wow, this is excellent. Why don't other countries apply the same scheme? So I hope that really we can get the same in other countries. Thank you.
Thank you.
Amen. All right, Michael, please.
Yeah, it's my presentation. Yeah, thank
Yes,
you.
It's your turn.
15 minutes? Yeah, I control it because I have 161 pages. Then I want to skip some. Yeah, because, yeah, that's the first page, right? And that's 10 years ago. I think one of participants' daughter sit over there. You see the left corner, primary school students, right? He will tell in her grandchildren. So back at that time, just 10 years ago, right now it's 10 years ago, but at that time we talked to her grandchildren. She said, oh, they talk about 60 million e-commerce dispute, eBay. And I know the ODR father talk about the Web.2 company. It's eBay, right? ODR. So at that time, you know the Web.2 it's not Web.1. Web.1 just read. And the Web.2 is interacting. It's reading the writing. People write the bad comments. Oh, eBay is bad. And whatever, right? The seller and the consumer. And then the ODR and eBay ODR center, Colin said, oh, get rid of the comments. Then use the eBay, like ODR center, right? The 60 million dispute a year annually. And Eastern Cat, that's a magic number. So right now we still talk about the e-commerce, right? This morning talk about the family law. So why not talk about something different, not e-commerce? So in the future, just like our grandparents told us that, oh, the movie is Charles Chaplin, silent movie. We still cite about that. That's a 2 dimension. Right now, we are in GPT time. It's metaverse time. And Colin wrote an article about ODR and the metaverse. How about the application? We still talk about e-commerce. So how about you said at that time and the CRT? Yeah, it's past resolution. It's 2012. So we are 2013. You're right. But anyway, that time the CRT had not opened the door until 2016, right? The first case. They talk about small claim, condominium dispute. Then talk about automobile injury accident case. But however, because of the due process issue, I remember, maybe you can, Simmi can correct me if I'm wrong. BC Supreme Court ruled part of CRT is unconstitutional because the due process issue. So how can you, Michael, you come here talk about the metaverse and the sexual harassment case? That's more complicated maybe than family law. Today we saw the morning, see the family law process, right? Zigzag, just like a snake, complicated. So right now, I can also, please, last slide. I control, you also control. I can control, right? And first, has the Chinese court ever used the meta course to resolve a real case? If not, then no. If yes, then it's possible, right? And before the public ODR, CRT, just 60 million e-commerce dispute. So that's a process, right? So when you talk about sexual harassment, so we supposed to have some met course, right? And verse court, and resolved like a civil and commercial dispute, straightforward dispute. So I'll show you. The first matter was trial opened in the local court in China. On September 23, 2022, the People's Court in Ximen district of Xiamen City in Fujian province held the trial of 2 instant subrogation cases in metaverse. the plaintiff was the same instant insurance company in both cases. So why the NCTR put out the first metaverse try on website because they want to say Lin Wing, right? Put on the website means to say you have to follow our ODR standard. So that time, like 10 years ago, we still talk about e-commerce. Like for example, onshore working group 2 ODR talk about e-commerce. So what's the ODR standard? Metaverse have a standard put in the in the onshore tech notes. I talk about the ODR standard. I see fast, and the Colin rule, and give me the list. They give the Martin call to support me. Give the name list. Then I shave the hands. Shave the name list in the onshore working group 2. So please, this working. I think this onshore tech notes is not for the participant. It's for this kind of ODR providers. Colin rule, right? In your module, you give me the like I did the phone call, and NCTDR is on the name list. Also, I see fast ODR standard. I stands for impartiality, right? Independent. C, S is simple. E, efficient, effective, fast, fair, accountability. How about the C? C, security again, because that time they didn't put the security into the unstable technology. That's ADR. That's not the ODR. If you ODR, you have to put the security in the notes, right? T is transparent. So that means NCTR recognizes metaverse as ODR. Yeah, fourth party. Now it's fourth party. No more. That's two direction. Web 3.1, Web 3.2. Now it's Web 3.3. ChatGPT, metaverse, LLM. So, in the metaverse court, the agent of the plaintiff insurance company stated that the defendants caused the traffic accident while driving a vehicle and didn't compensate for the damage after the plaintiff paid for the damage pursuant to its car insurance policy, and then sought reimbursement from the two defendants through legal litigation. Metaverse. Unlike online courtrooms that are 2D, the metaverse courtroom is 3D, which creates an immersive experience that gives the user a sense of speciality. Who is on my right, left, front, right? Just like a speciality. The user can quickly identify the position of the 3D avatars and the virtual objects in the surrounding virtual environment. Users can choose the preferred viewpoint to watch the court trial, allowing them to feel like they are in an in-person courtroom. The metaverse courtroom is also more convenient than a traditional courtroom, since it eliminates the need for litigation participants to attend a brick and mortar courtroom, physical courtroom. Instead, all the parties involved can scan a QR code and immediately log into the court trial site without downloading any apps. The metaverse courtroom also enhances the judicial efficiency and the transparency of the court trial. Unlike traditional court, which requires the litigation participant to oh, sorry, that's the same, right? Court. The metaverse courtroom offers more what's wrong with the keep doing? Oh, and then the traditional courtroom, unlike the past, where judge may need a magnifying glass to read the documents. In the metaverse courtroom, both judge and the user can easily zoom in or magnify the screen to review court transcript and examine evidence materials. As a result, it enhances the efficiency and the transparency of the court proceeding. Second, has the other court used the metaverse to resolve real case? The more real cases are resolved, the better chance for Chinese court to resolve addressing campus sexual harassment case. So before the CRT, there's 60 million e-commerce annually, right? So that means how many cases before the sex harassment case you can do, right? How many cases you guess? Oh my God, 10. Enough? That's enough, right? Please remember 10, 11, because if I have time, come back. I don't think I want to skip, right? 19 cases. If you don't trust me, seeing is believing, you can pick any case, I can explain it, okay? So right now, please skip it until 10 page 127, slide 127, skip all of them, because we don't have time. Right now it's maybe 11:43. So we are supposed to finish the 4 people 1 hour. Please go to 127. Yes, that's the number 127. Please skip. We have to keep the time, right? So 161 is too long. Yeah. Chaplain can. Oh. Third, did the Chinese court use the metaverse to address case of sexual harassment? Yes, that's different court, right? It's not in Xiamen. The Huashan People's Court. Huashan means flower and mountain in Chinese. And the Tongji Law School correspond a metaverse moot court. There was a legal dispute in the metaverse concerning sexual harassment. In the fictional case, a 20-year-old girl, that's school age, right, was the plaintiff, and a 36-year-old man was the defendant. Both were advanced users of the metaverse game, which allows the user to create avatars and personalize them to resemble their appearance and closely. The game also utilized the wearable device to provide more realistic and immersive experience. Slow down, don't worry. On October 10, 2022, the defendant approached the plaintiff in the game, lifted her chin and touched her face and kissed her without consent. Passerby witnessed the incident and laughed, which made the plaintiff feel humiliated and angry. She reported the matter to the game company, but they replied that the incident occurred because she had not enabled the safe mode option. This option blocks all intimate interaction within 1 minute of the player, which could prevent potential sexual harassment. The plaintiff was upset, embarrassed, and filed a complaint with the game company. However, the company responded by saying that the plaintiff had not activated the safe mode at the time of the incident. The company explained the safe mode option in this game can prevent any intimate interaction within 1 minute. Keep going. However, the company saying that plaintiff had not activated the safe mode at the time of the incident. Despite the plaintiff's complaint being rejected by the company, she felt that defendant's action were a form of sexual harassment causing her significant physical and emotional harm. As a result, the plaintiff hired a lawyer to protect her legal rights and interests through litigation. It's a metaverse dispute resolution. It's more moot court. It's not a real case. In the case, defendant behavior was, so I skip it maybe. Okay. Then fourth, has any court in other country used the metaverse to resolve dispute? A feasibility study from an international perspective. Canada, Colombia. So you just talk about your China, just socialist country. How about the common law? How about the civil law, other countries, right? So you're just unique. Sex harassment, talk about the metaverse. So we come here, we learn, we came common law system, civil law system, not from China. So you will learn from that. See? Metaverse moot in University of Ottawa. Right? Why is metaverse important? Society is going to be impacted by this technology as more people, business move online. For example, there could be workplace harassment during virtual meeting. Just cite it, right? That means support my argument. Who initiated? It's a young man, right? Young students. A third-year JD student is one of the drivers behind the faculty's push to digitalize academic operations at the common law section. So look at it. They are judges, real judge, you see? Justice and justice. Right? So even the case is fake, but justice is real. That would mean you cannot public ODR. And now we talk about civil law. On February 15, 2023, the Administrative Court conducted a court section from the metaverse to hear a case against Colombia Ministry of Defense and the national policy. Oh, what's wrong?
We just need to restart it again.
Oh, need a break because I'm kind of so time pressure. So I'm like tongue twist.
We gotta wrap it up, Michael.
Yeah, I wrap up.
Conversation.
I'm like tongue twist.
Yeah.
But some you can tell,
Good.
right?
There's a lot here.
Okay, yeah. So I'm keep going, yeah.
So we have
Colombia. So kind of that's, yeah, Colombia, also keep going.
That's Ottawa.
Yeah, Colombia, down.
Yeah.
So I want to know, so, oh, what's happened again?
No, it's coming right now.
Yeah, see? So metaverse, right? I want to know it's, metaverse was particularly used for legal case where people wanted to avoid confrontation. The metaverse could become helpful in proceedings where children were involved as witness, defendants, victims that relate to sex harassment, right? So talk about the due process. He said no, there's no due process issue. Just talk about it. Finally, so what makes the metaverse suitable solution for addressing incidents of sex harassment on campus? Necessity of mother of invention, right? Nanjing University. So again, again. So you have that's not my time, right? You have to save the time for me. This.
No worries, no worries.
Yeah. I
Let's-
kind of like running.
Can we, yeah, let's get the.
Oh,
let's
that's
get
from the
conclusion.
beginning again? I'm just a few slides.
Here we go. Here it is.
I think that I just finished 15 minutes. Yeah. You timing? Who timed?
I'm timing.
How many more minutes?
1 minute.
Oh, 1 more minute. Oh, 15. So that doesn't count, right? So what's that? 15, right? So that's ChatGPT did for us. It's not. It's you see. Made this. It's yeah, you can see it, right? DALLE made this picture. Yeah. So secondary victimization. So networks can help out that. See? What's secondary victimization? You know that I don't need to give it yeah, see? Again. So no ODR, no more. So people hate the ODR. That's why, see? So have another thing. 3 times.
So what's, you want to just wrap it up?
Yeah, wrap it up. Yeah, 15 minutes. Yeah. So wrap it up, see?
Could we use it?
Yeah. So that's wrap up. Okay? You can read it, fast reading. 1 minute. Okay, that's the last one. So could the Chinese code use LM8 metaverse as a first party in resolve campus section case? So this is, we can use it. So yeah, that's it. That's me. So CRT, yeah, okay.
Wonderful. Thank you, Michael. Very cool. Jeremy, take us away.
Yeah, I think I've got 5 minutes left.
No,
You can
30 minutes.
No.
We have 30 minutes left.
If you can you get the talk up? Yeah. Thank you very much for inviting me. Thanks, Prof. That was great. I went to an event that we all organised in Liverpool where people talked about Second Life, and Ethan, I think, spoke about how Second Life was going to revolutionise ODR. I was absolutely captivated. But unfortunately, being a criminal lawyer, my clients have managed to defeat all of that. The perverts took over Second Life, and it's gone. So I hope that the future that Ethan talked about, that we've just heard, can actually come to life in a virtual courtroom in the metaverse. Okay, introduction. Jeremy Barnett, criminal lawyer. I spend most of my time as a criminal judge in the UK, a recorder doing Crown Court cases. I was part of the ODR group. We went to Luxembourg, we've been to Paris, we went to Leeds, we've been to Florence. I met a lot of great people, learnt a lot of great stuff about ODR. I then ended up at UCL, where I'm the honorary professor of algorithmic regulation. I was given that title a few years ago, and my son said, "What the hell does that mean, Dad? You're just making it up." It's the regulation of algorithms and the regulation by algorithms. And my view of ODR is that its best use is in heavy-duty cases. And I've spent the last 25 years trying to do that. When I first started doing this, I was 6 foot tall, I had a head of hair, I had no beard, and I'm still here, and I'm no nearer. We've had virtual courts, myself, Fred Lederer, friend of Nicholas's, and with Professor Treleaven, who is the leading guy in the UK on algorithmic trading. We've written papers on the law of algorithms, we've written a textbook on the law of AI, and I'm still a lawyer, really worried about AI, and that's why I'm here. Because together with a very distinguished group, Nicholas Vermees, who invited me here to present our paper, Professor Frederick Lederer, who some of you know from Williamsburg, John Zelensikov, who I met in Florence 15, 20 years ago, great friend of Colin's. the prodigal son returns, to see Dan Rainey here, Colin, Ethan, because I come to talk about AI in trial. Why come to an ODR conference to talk about that? Because the conclusion that we've arrived at is that we need to pilot this stuff, as people said in the last session, in sandboxes, and we need to sandbox the technology before it's used in trial. So we've written a paper called Judicial Tech, which is available. We'll give you the link afterwards. It's published today for this event, and the four of us, together with Dory Riling, Professor David Ormrod from the UK, who's the leading criminal law academic, and others, have helped craft what we feel is a call to arms to the judiciary around the world to say we've got to be very careful of this stuff, and we can't say no because it's already here, but we need to be very careful before this is allowed to change our trial processes. I'm very interested in access to justice, which is one of the themes that's come through all of this, but I'm actually more interested in doing justice. And one of the issues that the football fans among you might understand is the debate about VAR we have in England. Should you have computers saying whether it was a goal or not, or should you have a referee? Well, VAR technology has ruined football. The TV now is all about whether the VAR was right. It's not about whether the decision was right. So what I want to talk about only for 5 minutes or so is judicial decision making, and how can we pilot that in online dispute resolution. And the point that was already made by an earlier speaker that we've concluded is that the difference between trials, criminal and civil, and ODR is people consent to ODR. They consent, and they can be asked to consent to the use of the AI. Now, why am I worried about this stuff? I'll tell you why. Fraud GPT. I'm a fraud lawyer. I don't know if any of you heard of Fraud GPT. Now, you don't need to work out your own fraud. You go to Fraud GPT, you download it, and it says, what sort of fraud do you want to do today? I fancy doing a pyramid selling fraud. Okay, who you target? Well, I fancy targeting 65 to 75-year-olds who live in Ottawa. Right, boom, 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 gives you a list. It gives you the fraud. It gives you the code to write the fraud, and it gives you the database of people to send it to. That's where we are with this stuff. And I say we have to be very careful, because we don't want AIs as judges. We don't want AIs as lawyers. We don't want AIs defending people, as will happen. Professor Ledra tells me if you put a camera in court, as you can do now with some of the kit, it can scan the faces of the jury. And it can say, that point didn't do very well. Alibi wasn't a very good defence. Why don't you try self-defence? I can't do that as a barrister because I'd be struck off, but the AI could. So the vision we have, and it's not far away, is an AI judge deciding the sentence, deciding whether you're guilty or not, deciding what material's available, deciding on the legal points, an AI lawyer defending an AI. We wrote a paper, Philip and myself, on whether or not AIs should be regulated. Should an AI have a personality? I won't go into that because I've only got 5 minutes left. Okay, very quick run through. That's the, where are we? Oh, hang on, we've gone backwards. So, oh, hang on. Right, let's go very quickly through this. We all know about different types of AI. I'm not going to go there. We're all worried about the use of the latest forms. And it's the super intelligence that really worries us, which I haven't put on the slide. As Richard Susskind says, what worries him is we don't know what we don't know, if we can use that expression. I don't know what's gone wrong here. Am I clicking the wrong button?
No, we've got to restart the
PowerPoint. So, the issues that we're looking, if we can flick through, yeah, next one, there is great potential. If we can just go back, there's document review, there's online filing, legal analytics, algorithmic dispute resolution. Philip and myself wrote a paper on that, which is really smart settle on steroids, if I can put it that way. I still believe in smart settle. I heard about it. I met Ernie over in Vancouver 15 years ago. Great technology. The potential is huge. But we're worried more about the last points there, judicial algorithms, sentencing, recidivism algorithms, facial recognition, identification of clients, of defendants, and computers as judges. Nicholas has written a paper. Should the computer be a judge? Should a computer be allowed to be a judge? And that's the theme that we've taken in our paper. If you'd like to just knock me through, can you take it? Yeah. Controversial. There's been a case that most of the lawyers here will know of, Loomis, where the algorithm that looked at risk of recidivism was approved by the Supreme Court. We get into prediction algorithms. Prediction of crime, racial profiling has been outlawed now in a number of American countries. We're worried about deep fakes in trial. Use of algorithms to create false data, fake video content. How is a judge going to decide whether or not the evidence should be permitted? And we get into the very complex area of auditing the algorithms. And this is really what this speech is about, this talk. The question that's been raised by an academic in the UK called Professor Wachter is, should the computer scientists be able to tell the judges whether or not the algorithms that they're going to be using should be used or not? Do they show bias? Do they show ethical issues? And are they risky? I say no. We can't leave this to the computer scientists. And I say that Philip Treleaven is one of our co-authors, a great friend. We can't let those guys decide how the trial's going to be run. The judges have to decide whether or not, I say, and others agree with us, I think, the judges have to decide in a trial whether or not the algorithm is fair, is biased, and they do so using expert evidence. And if it's a jury trial, the jury will decide whether or not the algorithm is correct, not a computer scientist. If you'd like to go through. There are clear advantages of the use of AI in trials, improved access to justice. Fred Lederer talks about landlord and tenant cases. 100% in his research of people who went to trial in a landlord and tenant case had no lawyer. 100% of the defendants had a lawyer. So yes, there is clearly a role for the use of this tech in access to justice, and that's where ODR comes in. We've got to look at fairness, we've got to look at auditing. If I can just go back, it's the disadvantages that worry me. Okay, leave it there. I learnt in Paris at our ODR event, must be 12 years ago, or I can't remember when it was, maybe Colin, you can remember. The French, at the bottom, the red one, no decision, judicial decision involving an assessment of a person's conduct shall be based on an automated process of personal data. In other words, that's really what I think we should have in our countries, including Singapore. Sorry, I forgot to mention the senior judge, Edith Mohammed Abdullah from Singapore, who has also helped us with our paper. The French have also said you can't now start analysing the results of the judge's decisions, predictive justice. And there it's very important. If you can anticipate what the judge is going to do, he or she, it tends to be 60% pro-claimant, and in industrial deafness cases, the damages are normally £125,000. You can run an algorithm to say the settlement figure is going to be £125,000. The other side runs their algorithm, and the two algorithms meet, and the case settles. I was taught about this in Paris, I remember. One of the speakers taught us about that. Very dangerous. Very dangerous from the rule of law, because it means there will be no more cases. And in the UK, we need litigants to come and bring their cases to court so the Court of Appeal can decide what the law is. If there's no cases, there's no new common law. GDPR, all the UK lawyers will be familiar with that one, actually stops judges, computers as judges. individuals shall have the right not to be subject of a decision based on automated decision making. The French, as I've said there, also have made it an offence to take statistical evidence of the judge's performance. So, why am I here? Because our conclusion is this, that there needs to be a roadmap. We need to use ODR to innovate. It's already being used to innovate. We need to capture the learning from the ODR and use that to inform the judiciary in all of our countries as to how this tech should be used in court. So the reason we came to that conclusion is, as I say, parties come to ODR and they consent to the process. They don't consent to being dragged screaming into a criminal or civil court. And therefore we say that the time to act is now. We need to improve the research capability of facilities like this, like Williamsburg, the Centre for Courtroom Technology, and other units around the world. And we need to be able to inform the judiciary, especially in the UK, but also in Canada, in Australia. John Zelenskov is very much in favour of what we're doing. And we basically say that this is a call to arms to look at the tech from the perspective of the court or the tribunal. That's why we call it judicial tech. The paper was published last night, is available there. If you go to SSRN, it's the website, and just type in the query judicial tech. That's the paper. If anybody wishes to contribute to it or add to it, then we would take, I think, further contributions. And our conclusion is, as was said in one of the earlier talks today, we need to sandbox in the same way we sandbox reg tech, financial tech, and other technology in controlled environment and look at the performance and say whether or not this is fit for purpose. Very well. Thank you very much indeed. I hope that was an interesting and short run through.
All right, Nico, you're up. Everybody can see you.
All right. Well, let me see if I can share the screen now. All right. So we live in a digital era. Most of the things we do now are through the internet, but I believe we're still linked to the old belief of what justice is. And justice is usually thought of as a place, and where we have to wear wigs or we have to dress in a particular way to get a dispute solved, and that's what actually Hollywood has shown us. That's basically why I studied law, thinking of justice of something that I will start wearing certain time, and magically become smart and make very cool arguments as attorneys in movies do. But let me show you the reality of Latin America. This is what happened in one of the judicial buildings in Cali, Colombia, and most of our justice is paper-based, still in 2023, and all of the files collapsed due to what we call the weight of the law. So this is the reality we have to deal with if we want to implement digital justice in emerging countries, and more so after the pandemic. Latin America was particularly affected by the pandemic. The restrictions on the use of public transportation, the restrictions on labor, the restrictions on movement were much harsher for our countries than they were elsewhere. And when it came to justice, most of the judicial systems in Latin America came to a halt. No judicial service was being provided for months. And then in the middle of that, that's what we used to say is, who could defend us? What could we do in that situation? in the middle of the pandemic, and the justice came as technology, and that's what you see over there is the red grasshopper. It's the Latin American parody of Superman, and it's also in a funny way. The way we started to implement technology into our judicial systems was strange, but let's take a look at it. So there were very positive things. For instance, Ecuador implemented the first judicial query system and by the Council of the Judiciary, and it was the first time people in Ecuador were able to check on the status of their processes online. And Colombia issued, in the middle of the pandemic, an emergency decree, Decree 806 of 2020, which was later passed as a permanent law in 2022, which basically allowed judges to use any available technological means for them to continue with the justice service. And of course, that came with the rise of the use of technological tools. For instance, in Mexico, the use of electronic signatures multiplied by almost 4 times after the pandemic, and many judges in several judicial powers started to use electronic and digital signatures. And there were some more adventurous judges. And in Cartagena, Colombia, a judge was the first in Latin America, as far as I know, that quoted ChatGPT as part of the grounds of a decision in a constitutional action, an action dealing with human rights. So this is quite groundbreaking. So when judges had the possibility to use technology, they started to use whatever they had at their disposal. And Professor Fang already mentioned one of the groundbreaking things that also a Colombian judge did. The magistrate of the administrative tribunal in Magdalena, Colombia, also held the first virtual hearing in the metaverse. And it was also done in accordance with this digital justice or enabling law. So this is how she looked, and this is how it worked for this particular hearing. Only once this was done. So maybe, is this the future? Is this, what we're looking for? I will claim that this is back to the future, because there were many things that didn't go well in the use of technology in Latin America. To begin with, many people in our region were not able to use internet. So they had no access whatsoever to internet. More or less a third of the population did not have proper internet access. And in 24 countries, the access to the internet was not reliable. So this was quite a limit. It was a barrier for many people, for almost a third of the population. And more so, even with the people who had access to internet, many of them were not computer literate. One of the barriers of the marginalized population that we've mentioned before in other panels. And then we still had all of our history of justice done in paper. So this is how a courtroom may look like in a Latin American country. So it's bundles and bundles of paper, usually tied up. And so the solution, or one of the solutions that we saw was for the judicial branches to provide scanners. But look what happened here. So 1 scanner for 4 judges. So is this the right solution? Just to scan all documents? And then in Mexico, the effect was that only 9% of the courts have an electronic court record. So look at this is a country of 120 million people. And more so, if you come to see, Latin America-wide, people started to use Zoom and other video conferencing softwares to hold hearings. And you may remember this anecdote that happened in the US with the filter of the cat. Well, we had more embarrassing ones in Latin America. This was an Argentine attorney who was in the middle of a hearing, only wearing his shirt, but his underwear was in between, and his camera fell. So that was quite evident. And then we had another judge, in this case in Colombia, who forgot her camera was on, and she was smoking, drinking alcohol, and laying in bed in the middle of a criminal case hearing. So, so this is the
Don't see the problem with that.
yeah. So this is what actually happened to us. So we had many technological means, but they were all dispersed. So, for instance, if you had to file a document in some Latin American countries, you had to submit it by email, by the judicial platform, the official platform provided by the judiciary, and sometimes there were some informal means via Facebook, via WhatsApp. So you could do the same work 3 or 4 times. So, of course, there was no efficiency being achieved with the use of technology. Sometimes cases start to take longer in Latin America because the procedure or the transition also into using technology was very complicated. And this is the situation. As of 2021, Latin America is the global region with the second lowest perception of justice. And if you come to ask me, quite honestly, this is part also of our culture. So we believe it's very urgent to adopt digital justice, but it will not happen today. So if you came to see it in this symbol, it's basically pretty much like a turtle, like slow, in trying to get some things done, but with not much effect. So how can we put a rocket? How can we change it? How are we going to make a real change in our system? And so if we want to look at an actual superhero, well, and we are at the ODR forum, of course, it's ODR. And taking into Susskind's claim for online courts, and online courts taking the methodology of ODR, I would claim that we cannot continue to do the same things as we do in Latin America. We try to change the wheel of a car which is already in movement. So we want to talk about digital justice, but we don't take the time to reflect. So we have to stop and change the wheel and try to change our mindset. And that requires an architecture. And this architecture, of course, is based on the 4 layers of ODR, basically picking on legal health promotion. How can we achieve that, particularly in Latin America? How can we materialize this purpose that we have for so many years? So, of course, we take the examples from what we've been discussing this morning. First, the assessment or the legal guidance. I think what the CRT does is terrific. So, as Colin said, whenever I look into a presentation of CRT, I say that's my ideal. I wish I could do something like what you guys do in Canada, and it's really remarkable. I wish I was there, no? But there's some of the limitations. And then, of course, taking the mediation, you have to have stages. You have to have layers. So, for instance, in Peru, the Lima Mart is a mediation center, which is only focused on online mediations. So we see that the part of the culture in Latin America can get adapted to that. And of course, the decision-making process. So I see arguments pro and con, but there are very interesting examples of what has happened in China over the past few years on how you can have very effective decision-making aided by algorithms and ODR platforms. But of course, that's somewhere else, and that might be digital justice in more developed countries. But what happens in emerging countries like Latin America? Well, I've been working for a few years with the aid and support and mentorship of Colin on how to implement ODR in Latin America through REDEC. REDEC basically translates into electronic dispute resolution in Spanish. And what we're doing is trying to promote an ODR platform that can be adapted to public bodies, companies, and of course, judicial institutions. So with the main idea of what we have three pillars in our methodology, which is the legal design, the automation, and the legal project management that all converge into having a customized product. So we do not believe that one size fits all kind of philosophy, but we can have many adapted ODR platforms depending on the need. And we have made this proposal to the Council of the Judiciary of Ecuador, the one that already installed the query system. That includes many of the steps that we've mentioned before. The claim identification or this assessment, online conciliation, and how we can do it, how can we prevent those from getting into the civil judge. So what we presented to the judiciary in Ecuador and Colombia is to have a filter. It will be a separate platform for conciliation or mediation that will prevent some of the money claim collections cases to arrive into the system. But of course, you know, you really want ODR. I love ODR, I've been promoting it for years, but there's always the fear of change. It's people might be excited at first, but then you come to see when you try to apply it in Latin America, our innovation ranking worldwide is very low. So even if people are interested, they're still afraid, and they didn't want to take steps unless it's completely safe. And safety also comes to cybersecurity. And we are also vulnerable in this sense, as it was shown in September 2023 with a cyber attack that affected in Colombia, the Colombian judicial branch. We actually had to suspend for a few days our judicial services again, as in the pandemic, due to cybersecurity concerns. Of course, there's the fear of the robot judge, and Professor Barnett has shown it very well. So there are many people who are extremely concerned of what's going on, and decisions that have been based in ChatGPT have been highly criticized by both academics and practitioners, and it's now going to be reviewed by the Constitutional Court of Colombia. So what do we do? So we want to apply, we want to innovate. So well, there are some critical success factors that I believe we have some tools to apply in Latin America, like leadership, strategy, expertise, technology, specification, and procurement. When it comes to leadership, and you want to have a robust governance and support from top institutions, well, you have very good examples that that's possible in our region, starting with Brazil, which has one of the most advanced digital governance systems in the world, as recognized by the World Bank, and Colombia, that had a loan by the Inter-American Development Bank for $100 million, which can be extensible for $500 million to implement digital transformation for the judiciary. But of course, that's not only about money or policy, it's also strategy. And we need to have a moderate transition. Many of the plans in Latin America, including the one I just mentioned in Colombia, are too ambitious. And we cannot pretend to have a big bang when we want to have concrete solutions. So you can find particular projects which have a really nice impact. For instance, in 2021, there was a virtual hearing method implemented for domestic violence in Bogota, and it handled 75% of the cases in a much more efficient way. So concrete projects can go longer paths than we do with very ambitious ones. When it comes to expertise, we have to train ourselves. We have to really understand what we do. And to avoid this issue with the Cartagena judge and ChatGPT, we have to get experts, and we can train them. So UNESCO has offered a massive online course directed to judges and lawyers on how to use artificial intelligence in an ethical manner. Another example for user friendliness or for specific kind of ODR platforms. Well, Brazil has the 4.0 e-justice program that allows Brazilian citizens to consult the list of assets and properties that can be judicially enforced, or foreclosures or seizure of assets. So and it's very user friendly with both mobile and web app applications. When it comes to procurement, and to have not a huge number of providers, but specific ones that can make a difference, you can find in Chile and in Colombia public procurement platforms that can allow for a better management and governance on how these public contracts are made. And with artificial intelligence, I think that should be promoted, but in an ethical manner, such as what Prometea has done in the past, applied in Argentina and Colombia with particular projects supported by the University of Buenos Aires. And more so, in July 2023, Peru just passed a law encouraging the use of artificial intelligence to improve justice services. So there's a particular provision in their AI law that deals with this possibility. So, well, yeah. I mean, is this just fantasy? And for many years, I thought that was the case. I got involved in ODR. That's how I met Colin and many of you back in 2012. And for years, I was a voice in the fish. I was just talking about it, and I didn't see any change. But I believe that more and more people are jumping into the ODR bus. I know it's very hard. I know
That's a good looking ODR bus. I like it.
Yeah, and I think there's a lot to be done. But what I truly believe is that digital justice, in particular to Latin America, is social justice. So we have to persist. And that's what we're here for. And yeah, well, again, thank you very much for having me. And I wish I was there, but you know, thanks to
Thank you,
technology.
Nico. Thank you.